Hello and welcome back to the Weighted Law podcast. I'm joined again by my colleague Anna Woodhoo, and today we're going to be talking about finances on divorce, which tends to be something that we deal with. Well, quite a big proportion of our caseload is advising people on how to resolve their finances when they're getting divorced. Sometimes we are just dealing with an agreement that they've already reached, or they don't really want advice on it. They just want it to be drawn up as a legal agreement. Other times we're starting from the absolute sort of bare bones of everything, advising them as to what should happen and then what might happen, and then obviously negotiating a settlement.
Yeah, I think it really varies, doesn't it? Some people, as you say, have had some discussions already, might have already even reached the bones of an agreement and want some advice on that. Some people haven't even yet made a decision that actually they want to separate and ultimately divorce, and they're just trying to get some of that information. And I talk to people about making informed decisions, so you can start to decide what you want to do. Perhaps there are do's and don'ts that you should be thinking about, and it's a good opportunity to have that discussion as early as possible so that they can then factor that into then what steps they take from there.
Yeah, I think that's really important. That's what I always say to clients. It's about making an informed decision, and obviously it's not for us to tell them what they should do. It's just for us to tell them what their options are, what the law says, and what is likely to happen, so that they can then decide what's best for them. And I always say to clients, there's a short-term position where if you're going through a separation and divorce, it's fairly unpleasant. Everybody's quite emotionally charged. Often parties are having to live in the same house whilst they're sorting everything out, which is really unpleasant and difficult. And so there's a tendency to want to just get things done as quickly as possible because they just want it to be over. And I always say to clients, that's the worst time to make any substantive decisions, because the short-term position is very different to the long-term position. And it's really thinking about how you might feel in a year or 2 years' time when you are living completely separate, and you wake up in the middle of the night and you think, okay, why did I do that? Particularly if the other party is living a very different lifestyle to yours. So it's trying to sort of factor in the emotional side of it, but bearing in mind where you want to be in the future and how you will feel in the future if you don't put the sort of the time and effort in to resolve it sensibly.
No, I definitely agree. I also tend to try and have quite an early conversation about priorities, because actually one person's very different to another, and as you say, we can advise them on the law, we can advise them how things work, but actually there may be quite compelling reasons as to why something is of particular importance to them. Is it the children? Is it the fact they're nearing retirement? Is it something to do with health? All these different competing factors, and it's really helpful for us to know, and also for clients themselves to know and identify what are their priorities here, because then we can advise them around those. Obviously we give full and comprehensive advice, but we can take that into account, and I think that's what helps tailor that discussion to each individual person.
And we have some clients that come and see us who really haven't got any idea at all about what their financial position is in terms of the matrimonial financial position. They don't really know anything about the finances because they might have been the parent that stayed at home to raise the children, and the other party very much dealt with all the financial side of it. Or personality-wise, they may just have not really enjoyed budgeting and financial management, and so the other person just stepped in, but it's meant that now that they've separated, they don't really know what their outgoings are each month and what's coming in and what assets they've got.
And I think we try and let people know early on, don't we, that that's okay. Actually, it's not going to be that you're going to be able to come to us with dates or figures and know everything. Some people do, and that's also absolutely fine. But if you don't, there are processes and ways that we then deal with that, and that we can get that information. Like it's okay not to know.
Yeah, and the form that we often, so when we start talking to clients, we obviously start talking about financial disclosure, which is something that we need to be able to advise them. And for those clients who come to us and say, well, we've reached an agreement, we don't actually want your advice on the agreement itself, we just want it drawn up, they may not provide us with full financial disclosure against our advice, but we need that financial disclosure to be able to say to a client, these are the sort of things you should factor in, and this would be a fair settlement. Or when the other party makes an offer, we can advise them whether or not that offer is fair, providing we know what the financial disclosure is and what's effectively in the matrimonial pot.
Yes.
And I think we all have come across cases where it's quite difficult to get that financial disclosure, because we tend to have a fairly standard way of obtaining financial disclosure, don't we?
Yeah. So typically we, or in mediation, or if you end up in the court process, you're using a document called Form E. And, it seems relatively lengthy, but actually it's just a way of compiling the necessary information, as you say, to have that full picture, get a full idea of what's there and what's available, and then be able to give informed advice and full and proper advice as to what the appropriate way of dividing that is.
Yeah.
And the Form E calls for a number of documents to be provided in support of it, so that you've got the evidence, the disclosure around the figures. So whether it's to do with values of property, somebody's income, whether you need pay slips or tax returns, bank account statements, any other assets, income, it just gives you that information that you need, or the mediator needs, or ultimately that a judge needs, to be able to have that view of the whole situation.
Yeah, and so it was designed obviously by the court as part of the court process, but as you say, we will use it on a voluntary basis, mediators will use it, if I'm doing a collaborative case, we'll use it. It looks quite cumbersome. It doesn't, not every part of it will apply to every, because it's a catch-all, isn't it? It's for people who own businesses, people who are employed, but it is a useful document. I think I say to clients, having it in one place rather than piecemeal bits of emails with things attached, and it's much easier to have it all in one place.
Well, and it also helps us, with the assistance of clients looking through it, to then identify if there are things actually that we're missing.
Yeah.
Actually, there's something referred to in here, or we can see that there's a question mark here, and it helps us plug those gaps, because you've got that full set of disclosure, or you hopefully have, but you can then pursue anything that you think needs further explanation, clarification, and deal with that. And hopefully, again, that's something that can be dealt with through that voluntary process, asking those questions and filling in those gaps. But if you're not in that process and you're in court proceedings, you then are directed to provide that information, and that's particularly important where you've got somebody that's not that forthcoming with their disclosure, and you've got big questions because your client's saying to you, well, I know this exists, or I remember this, and there are means to getting that information if you can't come together and do it cooperatively.
I mean, the majority of our cases, I would say, we don't have to involve the court. It's just there's a handful of cases, as you say, where it might be that disclosure isn't forthcoming. One party's really buried their head in the sand and just doesn't want to engage, and it becomes necessary to make an application to the court, because we need that disclosure for both parties to be able to move forward, and we need a timetable for the provision of it. I mean, I've had clients before that we agree to exchange on a voluntary basis. We send the form to them, and it's just overwhelming, and they'll look at the form and they'll think, I can't face that. And it is, there is a certain amount of work to it to get it right, but I think we would all say that investment of the time in a Form E being completed properly is going to save a lot of time down the line, and just it makes for a smoother process.
Absolutely. And I think, as you say, it's an investment, because that's your first key document and your first key piece of evidence that you're providing to say, this is me, this is us, this is our financial circumstances. And you will find throughout the process, whichever way it's being dealt with, people come back to that time and time again. And if you haven't put the time and effort into preparing that, and you can do so with as much or little assistance as you need. It's not all on your shoulders. And we've got various ways of assisting with that. But if you put the time and effort into doing that properly at the outset, it's going to serve you better in the long run than having a half-completed document that just ultimately raises more questions than it does give answers.
And so if I came to see you as a new client and I was saying to you, well, I don't know very much about the finances, but I know X, Y, and Z, we've got this property and we've got another property and my husband's got some pension provision. What would be the sort of the starting point in terms of the advice that the very general advice that you would give? Because obviously every case is fact specific. Every case is the disclosure plays a huge part in what advice you would give. But what are the general parameters in terms of resolving finances on divorce?
So I think the purpose of that initial meeting is information gathering and guiding somebody as to what to expect going forward. So initially I'm getting information from a client. I want to know things about, as much as they know about the financial circumstances, if they've got children. Also want to know how long they've been living together, how long they've been married, and as best as they can feed in this information, because that then helps shape the advice you're giving and the way forward. I would then explain that ultimately we advise on the basis of the same as a court would look at this, on something called the Matrimonial Causes Act, and that there's a number of factors that will be taken into account when looking at what the appropriate financial settlement is going to be, because, as you say, it's not one thing fits all. So you're considering how long have people been married and living together, what are the assets and resources available, are there any health considerations to take into account, what are the parties' ages, because does that impact their earning capacity or when they're likely to retire, and also the needs of any children. Have you got minor children? What are their arrangements, and on the ground, who's doing what to provide for them? Because you bring that all together and take that into account into ultimately looking at primarily 3 strands. You're looking at capital claims, so that's dealing with your property and any other cash assets, I would say, with also any consideration if there are any business interests or things like that around. So looking at capital and property. We also look at income claims, so dealing with spousal maintenance, child maintenance, and also any claims over pensions and pension sharing. And it's those 3 strands that I tend to advise on in that initial meeting based on somebody's circumstances. So we know, for example, that the starting point for the division of your marital assets is 50-50, but there can then be a departure from that, and it's ultimately coming down to needs. And I think that's where it differs, doesn't it? What assets does this couple have, but also what are their needs going forwards? And that will ultimately depend on their personal circumstances and the context of their case.
I think that's the thing, isn't it? That in the majority of cases, unless there is a huge asset base, the majority of cases are the needs trump everything else, don't they? It's how are the needs of the parties and any minor children going to be met by the assets that they've got. If they're fortunate enough to have a huge asset base, then a 50-50 division is far more straightforward and it does meet both parties' needs. And we have the scenario as well where you might have a client that's come in and said, well, we've been living together for 20 years, but actually we only got married 5 years ago. And that's obviously something that we have to advise clients, that cohabitation is counted because it's moved seamlessly into marriage. They've cohabited, then they've got married. That is taken into account in terms of the length of the marriage. So it wouldn't be seen as a 5-year marriage. It would be seen as, say, a 25-year marriage.
Yeah, exactly, which then has the potential to change the outcome somewhat. So, and I think as well, that initial meeting that we were talking about, I also like to talk about the ways in which you might deal with the finances, because again, different people come to it with different information and knowledge that they've got, and also what they are and aren't comfortable with. So whether it's having direct discussions with their spouse, could talk to them about mediation, can talk to them about solicitor-led disclosure and negotiations through that voluntary forming process, or ultimately through court proceedings, which is your worst case scenario. But it's helpful, I think, at that very start to start talking about the options when it comes to looking at how to resolve things, because I think it can all too easily feel like you're running out of options and you're being boxed in when you're in that situation. You've only got one house, one set of assets to divide, but actually talking to people and making them feel like they have choices and that there are options to this gives them that sense of control and being able to make some decisions where they might not have felt able to.
I think that's very true, and I think because there is always an option, sometimes there has to be a compromise to reach that option, but there are always options. And I think that's the difference as well with being able to resolve it outside of court. You've got more options because you can be a bit more creative.
Yeah.
Obviously, if you're before a judge and he's having to, or she's having to make the final decision, they're limited in terms of what they can actually do.
Yeah. When I often say to people, if you're able to come together and make your own decision, it's not necessarily one that either of you particularly like, but it's one you can both move forward with.
Yeah.
But if you put that decision in the hands of a judge, then ultimately he or she is making that decision, and you've got no control over that. And it may be something that neither of you particularly want. It doesn't really work for either of you.
Yeah.
But you've had that sort of control and involvement in that decision making taken away from you.
Yeah. And there are some cases where unfortunately that is the only option. But that doesn't mean that when the judge makes the final decision, one of the parties may not be very happy with it, and that can then continue the process. So I think we would always encourage people clients to reach an agreement. And ultimately, I think I know all of our team, but we would always say to clients when we're talking about this, that the best option is to be able to lodge a consent order with the court, which is an order by consent, which we have agreed with the other side, and which, as you say, they have then got a level of control over what happens. Yes, there has to be compromise, but it's not being imposed upon them, and they can agree timeframes, things like that they wouldn't be able to do.
Well, and often they've reached that point, haven't they, without as much cost or delay as might otherwise be,
and as much emotional cost, which then has an impact on everybody as well, doesn't it? The anger, having to end up in a court situation where you're spending a fortune and then someone's telling you what's going to happen with your own assets is...
And particularly if you're still co-parenting, for example, going forwards, if you've been actually able to resolve something amicably and by agreement, it leaves you in a much better position to then move forwards, being able to at least communicate with one another and working together for those children, than if you've come off the back of 18 months of very bitter and upsetting divorce proceedings.
Yeah, absolutely. Okay, well, thank you very much.
Thank you.
And we will see you next time on the next episode of the Way to the Law podcast.